The
This
blue book for the,
conference will now be recorded.
okay, now that we've got the legal requirement out of the way, that we've told you that we're recording this, don't say anything that you won't be proud of tomorrow. But having said that, I want to thank Lenny and the Blue Book. I've had a long relationship with the Serbini family, Lenny and his family, and the Blue Book going back to my first days as an attorney here in Florida. I want to tell you that 12 weeks ago, I knew nothing about coronavirus, COVID-19, or any sort of pandemic, and this is all new to us. What we've been doing here at the Soto Law Group for the last 10 weeks, plus or minus, is monitoring the developments both nationally, in the state of Florida, and locally on behalf of our clients to be able to give them advice that they can rely on and move forward with their construction businesses. First, I want to talk about what this is all kind of meant and what my experience as an attorney and obviously as a business owner here in South Florida have reflected. First, it started off as slow down, social distancing, then it evolved to stop, wait, and then it evolved, and all of this was happening, sometimes overlapping, sometimes one before the other, but eventually we got to a place very quickly where it was determined that, utilizing the phrase essential businesses, that the construction industry would be one of the few large industries in Florida that had a chance to survive during the various stages of the lockdown. And that was obviously very beneficial not only to the general economy, but to all of our friends and colleagues. I want to talk about the 3 F's that I've come to kind of attribute to this virus. I'm just going to call it the virus. You can call it what you want. But anyway, I use 3 F's. One is fluid. One is Fauci, because every time Dr. Anthony Fauci speaks, we listen. Whether we agree with him or not, he impacts a lot of what's going on, what's been going on for the last 10 weeks. And the 3rd F is the word forever. I really believe that when we do come out of this, there are going to be lasting and permanent requirements, obligations, and duties imposed on the construction industry nationally, if not universally. So what have been my experiences as a construction lawyer over the last 8 weeks? Well, I've gotten calls from clients on a regular basis where the contractors that I represent are having projects that are terminated for convenience. That is, we're not going to start or continue the project in the short term. So we've had to look at termination for convenience clause, and we'll talk about that in a minute. We've also had situations where a project has been suspended. It's not terminated, it's suspended. Again, we look at the contract and we'll talk about that some more. Other impacts that we've observed in the last 8 weeks has been the issue of ongoing projects and permit inspections. So the use of private inspectors and so on has exploded because most of the governmental entities are in partial lockdown, partial closure, and reduced staffing, if they're even open. And so that has allowed some projects, if not most, to continue to proceed where the authority having jurisdiction is not able to support all of the projects or any of the projects. We've had job interruption experiences. We had a client who went to a project, a large 50-story project in Miami, and was told by the contractor, the client in our case was a subcontractor, was told that someone had either tested positive for the virus or was related to someone who had tested positive for the virus, that particular person was employed by a subcontractor, but they were going to have to send everyone home until they had full testing. So that project got closed down. But what the interesting thing about it was that subcontractor, who had no one who then currently was tested positive, went to another project with his crews thinking, well, if I can't work there, I'll work somewhere else. And when he got to that project, the contractor on that project became aware of the problems on the other project and basically banned and barred that subcontractor from coming on another job, even though they weren't accused of having anyone who was, positive for the virus. So that kind of thing has happened. It's probably happened to all of you in one way or another, or you've heard about it. So these kind of things are something that you have to react to, manage, anticipate, and be ready. Other things that we're seeing here are, the cautioning. General contractors, subcontractors are advising their employees and workers of the virus, the impacts of the virus, not just from a financial standpoint, but from the standpoint of job safety, job security, health safety, and in writing telling their employees that this is what we're doing to try to ensure your safety. Nothing's perfect, nothing's guaranteed. No scientist really knows the limitations of how this virus is communicated. We think we know, but truthfully, we're all sort of just kind of grappling with what we hear. In any event, so I've seen a number of contractor clients and owner clients issuing what I would call, 10 commandments or edicts of how we're going to run this job go forward. So at the end of the day, what that really means, in my experience has been, is the means and methods. We all hear about that in the construction industry. The contractors and the subcontractors control the means and method of how you furnish your labor, material, and services. But now we're having these means and methods, a layer placed over it, which what I'd call the virus, the coronavirus or COVID-19 procedures. And we're going to talk about those a little bit later, but those are affecting efficiency and the speed in which you can construct. So you have to be aware that those are fluid. Some of those are coming out of government organizations. They're being filtered through private entities, and they're manifesting themselves in slightly different ways in different projects around the state of Florida. Remember, 67 counties all over the state of Florida, all of which are grappling with this in slightly different ways. In any event, I just wanted to give you my experiences to date as a construction lawyer managing the needs of our clients. In some cases early on, we were writing letters that were confirming that within a particular jurisdiction, a particular client's, work was essential, quotes around essential, so that if they were stopped at projects or on the way to projects, they would have a letter that they could show. And after a while, it became pretty common knowledge around the state of Florida that the construction industry and anything related to the construction industry was basically a fully exempt process, essential services. So anyway, having said that and kind of framing what we've been doing, let's talk about our presentation. I'm going to skip through the second slide is just a series of talking points that we're going to address as we go through this, and I'm going to dive right into the third slide of the presentation. What we have here, and again, I said there were the 3 F's. Fluid was the first one. Everything that we show you was current as of a day or two ago. It may have changed overnight in a particular state, but as you can see from this graph, there are, and this was very recently, there are certain states that don't have any restrictions, and that would be, I believe that would be like North Dakota, South Dakota, Iowa, Nebraska, and Arkansas from the map. Then you have some localized issues in other states, which are the lighter blue. And then you have essential. Now, this is a construction map. This is what you can and cannot do. I think most interesting from this map to understand is that some states went the complete opposite of Florida. If your businesses had any operations in New York and New Jersey, you were effectively shut down, and I think are still shut down. I work for a company in New York that has Florida operations, several actually, and they have been locked down and working very hard to try to get back to work, but in essence, they have shut down billions of dollars of work in states like New York and New Jersey and Michigan. Now, what's interesting is that while California here is blue, I can't really tell you that California shouldn't be dark blue. they've shut down in various cities, the construction industry, but so I'm not really sure what California is doing today. But at the end of the day, open construction sites, regardless of the type of construction, have been deemed by the Florida governor and his Executive Order 2020-91 as essential businesses. And whether the governor got there first or various counties got there first really doesn't matter. It's been fairly essential from the get-go. And in the chart, in the slide we have up, you can see that we've talked about the specific businesses that are covered by these executive orders and some of the county orders. We threw in the Broward County order. Architects, engineers, surveyors. Now, it's supposed to be only with regards to ongoing projects, construction projects, where the work is commenced, and provided that you comply with all of the safety regulations that are either applicable through the county, the city, and primarily they rely on the Centers for Disease Control, and they rely on OSHA. And a combination there, OSHA might be parroting the CDC. But in any event, and we'll come to what those have phased into or morphed into, but this is sort of an overview of the U.S., and I think the major takeaway is we're very fortunate in Florida. I'm not saying we're not getting, significantly impacted, but we're very fortunate not to be in one of the dark blue states or states that were dark blue. In any event, that is essential businesses. We haven't really had any cases or any situations where a client was on the verge of starting a project and was unable to get a permit because the permitting authorities tried to interpret these rules that it shuts down jobs that are about to start, that are capable of starting. I do know several projects, roofing primarily, and we're about to head into the hurricane season, where the cities and the relevant jurisdictions having authority have said, hey, bring us your work. We're gonna fast track your permit because we understand the virus, but we also understand that we've got this other big issue looming out there on the weather front, which is the hurricane season. And if you need a roof job, we're going to fast track that. So this executive order has not been literally applied, as far as I know, in terms of stopping projects from actually starting. Now, you may have examples in other parts of the state that have had that problem, and I'd be curious to hear about them. Typically, the developers who haven't started, their lenders and the developers may have made the decision to, tap the brakes or push the brakes down. In any event, that is just talking about that. I'm going to move to the next slide, folks. Again, if you have a question, you can text it in. My colleague, Allison Andrade, is going to be fielding those and showing them to me, and I'll try to answer them in real time. If not, I'll do them afterwards. And I want to thank her, by the way. I'm going to stop right now. She is the author of much of the formatting and the technology that got this done for us. In any event, so we move to the next slide. Let's see if I can do that. Okay, excellent. I was able to hit the button and actually move the page. So we're talking about, U.S. states that are opening up phase one. What does it look like? So again, Florida has deemed construction activities, and I'm just going to use that as a placeholder. I'm not, trying to parse out words, but we're already essential. So when we talk about phased opening in Florida, we're not really talking about the construction industry. We're talking about other businesses. Up to, I think 2 weeks ago, Governor DeSantis decided to start opening the state of Florida. We have 67 counties, as I said, at least the last time I looked. Of those 67 counties, most of the counties from a numerical standpoint, 63, 64, 62, made it into the first sort of relaxed restrictions. Several counties, of which Broward, Miami-Dade, and Palm Beach, were held back from that initial relaxing of restrictions just a few days ago, Palm Beach County slid into that same group of large counties that are now in that early phase 1 of relaxed restrictions. What we've done here, and why this is important to you, I think, as a construction industry professional, is some of these businesses that are opening are your customers, are your clients, are your future work. And if they weren't open, they weren't going to spend money to move forward on projects depending on their situation. So you have marinas and golf courses in some of these locations that are open, outdoor recreational beaches, which, you know, while we all enjoy that, it's not really a construction industry focus at this point. So other states are moving in that direction. So what does phase 1 look like? We're starting to see, you know, the hospitals, the restaurants, retail starting to open up with, like, you know, pushing the door open with their toes. I'm optimistic on that. Again, I'm not here to talk about the medical or the science. I think there are a lot smarter people than me who are talking about that. I can tell you that I watched them all, and I don't have any predictions on whether anyone's right or wrong. The numbers are what they are, and the numbers are subject to some discussion. But at the end of the day, it's certainly apparent to me that the country, in a staggered fashion, is starting to stand up, and I think that'll have positive benefits. Obviously, Florida was, you know, in a much better position than other states. In any event, that's what's going on in that phase 1, and I believe that Dade County and Broward are looking at their easing of restrictions. I heard yesterday, next week, May 18th, I've heard the county mayor of Miami or the city of Miami mayor say something similar. So again, they're going to make decisions in a kind of a fine-tuning methodology, and then watch the numbers. It's about watching the numbers. And again, when I said earlier, you know, fluid, this all can change. I don't expect it to, but it all could change as the knowledge base gets deeper, et cetera, et cetera. So let me move to the next slide, which is, you know, a look into Florida. How does reopening America apply? Well, here I've got my 67 counties. We know we're essential. We know that Broward, I've just spoken about some of this, that we're opening. I want to emphasize bullet number 3 on this page 5 of the slide presentation. The construction industry, this is not as simple, and it's not as simple as it was 8 weeks ago. 8 weeks ago, we were deemed an essential business, maybe 10 weeks ago, whatever that number is, and we kept working. I don't think in those early days that we were working differently. Masks, face masks, social distancing. I don't believe in the early days that had fully rolled out, fully penetrated the construction industry. But today, and I'm not on construction projects every day. I either drive by them or I talk to folks in conference calls, blah, blah, blah. But again, I believe the CDC and OSHA have out very straightforward, but subject to a lot of flexibility interpretations of what your workers should be doing on projects. Again, it's fluid, it's different in some places. On some projects, the owners, the developers, the authorities having jurisdiction have a lesser concern, either because they're in a county that has, I'm going to pick a county here, I'm going to go with Lake County. If you're out of Lake County, don't take this personal, but in a Lake County that may not have had very many virus, people tested positive for the virus or virus issues. So projects there might be exactly as they were 3 months ago. But if you moved to Miami-Dade County and went to one of the high-profile projects, everyone is probably wearing a mask. Everyone, there are probably plastic shields available. They have now created situations where there's one egress into the project. There's one egress going vertical, floor to floor, and then a different egress. That is, you come down a different set of stairs. They are involved in significant real-time sanitizing. Wow, that is a huge issue in the construction industry, because that's not something that typically happens before coronavirus. But now they're wiping down handrails, they're wiping down things that are commonly used, your toolboxes, your big boxes, so equipment that's on rental or bare rental or manned rental. So things are happening differently on different projects, and I think we used to use the phrase, we still do, best practices. Each of your firms should be developing best practices and determining how they fit your situation, how you can roll them out, and how you can ensure that your folks are getting the benefit of best practices. And we'll talk about that a little bit later. But again, this is kind of an overview. I'm going to move to the next slide. So, what are some of the issues we have encountered in our practice as construction lawyers? Well, the first thing is and what's interesting, and I'm going to stop for a second and go kind of sideways. There have been more seminars, more webinars, more Zoom meetings, more of these go-to-meetings in the last 6 weeks than I've seen in my entire 32-year career. And every lawyer, every CPA, every consulting company that's of any significant size or footprint has been rolling out one webinar, one go-to-meeting, one educational opportunity after another. And they're great. Most of them are very specific to the areas that they're focused on, whether it's manufacturing, medical, etc. But if you have the ability to attend any of those, I suggest it. They're very, very informative. I don't think you could do it every day. You'll get overwhelmed, and frankly, you'll want to kill yourself after too many of these. But in our industry, force majeure clauses were like the first thing off of every construction lawyer's lips when the lockdowns came. And whether they were lockdowns to Florida or not, the impact of the virus and potentially the impact of the virus that we've moved to, there was some talk in Florida of moving to a lockdown situation even for the construction industry. Now remember, a lot of things in this world are based on lobbying and political influence. I know the construction industry associations of Florida and nationally, went to bat hard for our industry. And we're successful in deeming it an essential business. As for a lot of other industries, it's not just our industry. But anyway, the force majeure clause, I'm going to kind of try to give you a layperson's concept of force majeure. It is a concept in the law, not necessarily in a contract. It can be in a contract, but it's not necessarily in a contract. It's just the law. The law in Florida is a kind of a common law that we inherited from, over several hundreds of years, some of it from England, some of it from other countries. In Louisiana, they've got a lot of French canon law. Other states have the blend of other laws that creeped in over the various hundreds of years. But the common law is that if a particular event impacts your project, your contract obligations, then there is a relief valve. That is, hey, we're not going to hold either side of the contract, the parties, to their obligations as a strict requirement. We're going to open up the relief valve like you do on, boilers and what have you, and let some of the steam and pressure off, and let's see whether it really does affect and how we mitigate the situation. So what we have here are just 2 examples. There are hundreds of examples of force majeure clauses that I've encountered in my practice over the years, and they're written differently. I've had experience back in the 90s. We had Hurricane Andrew, so we had act of God issues that came up in force majeure. Then we had several other hurricanes. Then we had, I'll give you an example backing up to Hurricane Andrew because it's kind of similar to all the hurricanes I've experienced over the 30 years I've been doing this. Hurricane doesn't necessarily have to hit your county for you to have a hurricane impact. Here in South Florida, the Hurricane Andrew hit in South Miami. It literally drained in the two days after the hurricane had passed and the weather returned, but the damage was done. And for the next 6 months to a year, South Miami drained every roofer, every carpenter off almost every job in the south of Lake Okeechobee, and from around the country, contractors descended on South Florida because the money being spent by insurance companies and individuals to rebuild was off the charts, and the rates they were getting were better than they were getting before the hurricane. So there were force majeure clause claims made by businesses outside of Miami. So it can have an impact on you. So let's just go through the first example of the clause. A party is not liable for any failure or delay in performing the agreement if such failure or delay is beyond the reasonable control of a party, materially affects the performance of the obligation, and could not have been foreseen. So I paraphrased it. It's all there, and so is example two. But basically, it's out of your control. I've not heard one lawyer or one consultant say that this coronavirus is not a force majeure event, that it's not an act of God. However, when you balance that with the fact that Florida has deemed us an essential business, a force majeure clause may not have any relevance to your contract if the work has proceeded and you're performing the work. Now, I say that, but I don't mean that. There is a flavor to everything. You may be proceeding with the work, but the cost of the work may be more expensive because of all the new proactive measures you're having to take in terms of complying with OSHA or CDC, et cetera, et cetera. So additionally, because now you've got social distancing, however that is enforced on your project, it may be taking you longer to perform the work. You're still performing it, but it's taking longer. So there may be an efficiency problem. There may be supply chain problems, and we've had a lot of discussions on these kind of conference calls about supply. Now, I've heard about anecdotally supply issues with meat and poultry and other food items. Obviously, with toilet paper, we all know about that one. But other items. But in the construction industry, I've not yet heard supply chain problems, but I'm sure they exist. I'm sure that there are certain kinds of products. Well, obviously, having those special masks were very difficult to get. But in terms of particular products that might have come out of China or places like that have had some issues maintaining the supply chain or diverting the supply chain. So while you're still working, you may have a force majeure event or opportunity to at least make the claim. In the days right after the lockdowns, in the days right after the shock of this event and what it might actually roll out to be, a lot of contractors and some major subcontractors were sending out form letters to all of their customers saying, look, this is the event. We think it's a force majeure event. That is an act of God, unforeseeable, and all of those things that are here. You need to be aware of it. We will monitor the situation. We will let you know how it affects it, but we're putting you on notice of that to comply with our contractual obligations. And as soon as we get through this, as soon as we know what it's going to cost, we'll let you know. So that's what a lot of contractors and major subcontractors did who had multiple projects. And that was pretty darn smart. Now, if you didn't do that and you didn't have any impacts that you know of, you're okay. But if you didn't do that and you've had impacts, you should go ahead and send out that kind of a notice. I don't think the delay, I don't think anybody's going to fight you in retrospect and try to argue that that's not an event. But in any event, so I'm going to move on to the next slide because I want to talk about how does the contract clauses work. So we got this checklist. It's not the end be all, but it's a starting point. You can make your own. You know, how is the event defined? Here it's clearly out of your control. It's an act of God in some way, shape, or form. What's your clause say? Does it require you to do anything, to say anything in terms of notices, special words? Again, there are 100 different versions of these force majeure clauses. You have to read them, and then you have to react to them. And what are you doing to, take reasonable efforts to minimize the impact? What are the designated consequences? I've had at least 3 or 4 projects that have been suspended, not commenced, or terminated for convenience because of the virus. But I've got way more projects that are still moving forward because they were already in the pipeline or they're very important to the customer, like roofing projects, renovation projects, where, things are happening. In any event, so you need to drill down on your contracts. Every good contract, whether it's a purchase order, a terms and conditions on a sales document, a subcontract, a prime contract, even architectural engineering contracts, need to have a version of a force majeure clause. And you need to really read it and talk about, how you want it to read, not only for this event, but for future events. In any event, and what we have on the next slide is just talking about, generally what is Florida law. And it's very consistent with what I've been saying is, look, not under our control, not foreseeable, we didn't create it, we couldn't have prevented it, we can't control the government and how the government reacts, and we can't control, the supply lines, other subcontractors. I mean, there have been some companies that have just said, we're going to shut down. And so they've created a hole either in the trade forces or in other activities. I think that's rare, but that has happened in at least one case that I know of. So as we move to the slide 9, I like to wrap up the force majeure by saying, well, if that Latin phrase or that unusual legal phrase is kind of putting you off, let me talk about it in the context of the impossibility doctrine. And the impossibility doctrine basically says if you can't perform, you can't perform. If the reason you can't perform is not your fault, you can't perform. Now, the impossibility doctrine can typically, depending on the facts of your situation, can allow both parties to walk away from the contract. So you might have a project that stopped. You're not allowed to go forward for one reason or another. Could be a crazy mayor in a city, could be a crazy governor, it could be something. And when the dust settles and you're allowed to go back to work, that contract no longer works for you. The cost of labor's gone up, the cost of materials, the cost of doing the job. You had other jobs lined up. You can no longer do this one. It doesn't fit in your schedule. I mean, there could be, hundreds of reasons. And so you might want to look at this concept of impossibility of performance, the impossibility doctrine. It's very fact-driven. It's very, lawyers trying to fit the facts into boxes and give you, basically a walk-away situation. In any event, that's still out there. That's a possibility. I thought I would let you know about that. In any event, move on, trying to stay on schedule here. So what other things are we seeing with the virus? Terminations. So terminations for cause, we all know what that means. One side breached the contract in some material way, either didn't pay for the work or didn't perform the work, and there's no excuses. There's no force majeure event. There's no other issues that would relieve them of their breach. We're not here to talk about termination for cause. that's a seminar unto itself to talk about, what is cause, what is material, what is not, and a lot of the things that go into that. But we're here to talk about terminations for convenience. Terminations for convenience as a clause, and I've been doing this, over the 80s, 90s, and the first 2 decades of this century. So I've touched different parts of the industry over a long period of time, and I didn't really see terminations for convenience as existing prior to like the mid to late 90s. I'm sure they existed. I'm sure good lawyers wrote them. But now terminations for convenience clauses are the norm in your typical significant prime contracts. They're the norm in a variety of industry-leading contract templates. So we all heard of the AIA construction documents. AIA stands for the American Institute of Architects. That group goes back to the 1800s, started in the late 1800s in New York, I believe it was New York, and now is worldwide, and they have a suite or a menu, a smorgasbord of construction documents that you can use for professionals, consultants, architects, contractors and owners, contractors and subcontractors, design, build, construction management. So they've got a whole menu of all these different options, and most of them contain a standard state-of-the-art termination for convenience clause. Now, what we lawyers do is we take the templates and we play with them. If we're representing the owner, we make them slightly owner-friendly. And then the contractors try to pull them back and make them either fair or contractor-friendly. And that's a push and pull. But those termination for convenience clauses are very, very important for you to look at if that situation is triggered either as a subcontractor, a supplier with a contract on a job, and a contractor owner. You have to look at it very carefully. And who has the right to terminate for convenience? Typically, it's just the owner, but it could be different. You have to look at it very carefully. So what we have put here on page 10 is just some sample language from the standard AIA A201 General Conditions 2017 version. As many of you know, the AIA contracts typically get an overhaul or tweaking or substantial changes or additions about every 10 years. Sometimes there's some that come out in between, but about every 10 years. So I was around for when I first started, the 1987 version was applicable. And then while I was early in my practice, the 97 came into play. The 97 is the first version of these that had the waiver of consequential damages for anyone who's in my age group and remembers that. And then in 2007, we had another version, and then the last version is 2017. So we're not expected to see another major overhaul in what I call the base documents for another few years. In any event, we put what these clauses say, and what I'm just trying to point you to is look in your contracts, if you haven't already, and you have issues like that. What are you entitled to? What are your options? And how do you go about exercising your options? Very, very important. So, like I said, I've already had at least 2 or 3 clients call me and say, Oscar, this job, one was a small job, a Jiffy Lube, maybe $1.5 million, $2 million. I just finished one for this client, and I was getting ready to start the other one, and he sent me a termination for convenience. And I said, Bill, is it in your contract? Yes, it is. It is what it is, Bill. That's his right, her right. And we didn't get all crazy about it. We read the contract, we reacted to it. We said we'll work with you. We had done some mobilization, but we demobilized, and we're hoping to restart that project when the smoke clears. So that has happened. Now, there are other scenarios like suspensions. Maybe the project had started, but for whatever reasons, lender issues, specific issues, they suspended the work. Just decided let's go on hold for a while. I have not seen a lot of that, but I'm sure it has happened. And in those situations, again, I point you back to your contract. Either if you're a subcontractor or a sub-subcontractor, you may have what's called a flow down or an incorporation by reference clause. Basically, what it typically says is you, sub or sub-sub, are bound to the upstream contractor, either prime sub or prime contractor, in the same way that they are bound to the owner. So you have these clauses that flow down, and so not only do you have to look at your situation, you have to look at the other contract documents that are upstream to see what rights or obligations or opportunities exist. So that's an important thing for downstream subcontractors to be aware of. So on the termination, on the suspensions, I talk about communication, being in constant contact. Where are we? Where are we going? Where are we going for the next 2 weeks? Where are we going for the month? Schedules are going to change probably regularly, depending on how the work is being efforted, how the means and methods are affected, how the timing is affected. But again, I keep pointing back toward the Centers for Disease Control and OSHA and what they've currently got out on their websites in terms of best practices. I'm not aware of, like construction police yet, but I'm sure there's policing going on project sites, both in the morning and leaving in the afternoons, and how the workers are interacting. I'm sure that there is obviously more policing on the bigger projects and less on the smaller ones. In any event, keep track of any changes in the way your work is being performed, because you need to advise upstream your customer, owner, contractor, how you're being affected. You don't want to tell them 3, 4, 6 months from now that you had all these impacts, you kept working, but you didn't notify them, you didn't monetize, you didn't tell them what was the financial or time cost of what was happening. So I just want you to be aware of that. So terminations for convenience, suspensions, and the rights of the different parties is set forth in your documents. If your documents don't have clauses that permit you to terminate for convenience or cover suspensions or the like, you can fall back on a force majeure event and say, this is what we're going to do. But realizing if you haven't already negotiated the what ifs and what happens if a what if event occurs, after a force majeure event disappears, you're going to have some difficulties in negotiating where you are and where you want to go, because you haven't previously set forth the parameters of how that would be dealt with. So in any event, those are the kind of contract issues. They're not all-inclusive. They're general. These are the kind of clauses that we've been looking at. Obviously, if you get into safety OSHA issues, you're going to have to go to your safety sections of your general conditions or your contracts to see how that is impacted. But I'm fairly certain you're going to have to comply in most cases, whether it's in your contract or not. So moving forward, let's talk about some other issues. The one thing I didn't talk about in my sort of opening dialogue is, what else is happening? So in the first manifestations of the relief efforts out of the U.S. Congress, you got a bunch of these federal legislations and monies and programs that were created, extended, and enlarged. And I can tell you, I'm not an expert in these things. I like everyone else, I run a business, I consult with businesses, I work with a lot of folks, and we all had to become as expert as we could in a very short period of time. Every one of my clients, with some exceptions, who didn't, who were either public companies or had more than 500 employees, or their operations were just too large, was, caught up in the Paycheck Protection Program and the various banks and getting their applications in, getting that whole process. So we're going to come to that in a second. But there were other programs out there the Family's First Coronavirus Response Act, what we refer to as FFCRA. Everything in the federal government has like 6 acronyms. Nothing is small. So then they try to come up with a short title. The CARES Act was fairly straightforward. The Affordable Care Act was fairly straightforward. But, sometimes you got to follow the names of these things, and you've got to kind of understand. So right now, depending on whether your business is in the category of the you're required to comply with certain provisions, and it depends on the number of employees. It depends on not only the absolute number total you have, but if you have less than a certain number, it doesn't apply to you. There's additional paid sick leave that's out there, and I've related some of that here on page 12. You need to be aware of these things, because one thing we're going to see a lot of in the coming weeks, months, and years is more employment litigation, more insurance litigation. The insurance litigation is primarily going to be limited to business interruption insurance. I have not covered that in this slide presentation. There are a number of webinars out there that you can go to. Believe me, the business interruption claims are mounting. The law firms in Florida are starting to advertise like crazy for it. I'm not going to use any names. You all know the law firms that advertise for these kind of large contingency type work, but they're going to try to make insurance companies, depending on the language of the insurance policy, pay for the business interruption. And I'm just going to add my kind of take on that. It depends on the policy language. You got to pull it out, review it, have a professional review it. We review them here. Then look at, were you really interrupted? What's your deductible? What are the exceptions and limitations? If you got the Paycheck Protection Program, does that get offset against your business interruption? I would suggest potentially yes. Again, language of the policy, the insurance case law. But again, business interruption questions, you need to kind of box those up and deal with those separate and apart from what I'm discussing. If you haven't looked, you should. I'm not sure that there's going to be a big opportunity there for a variety of reasons for the construction industry, but I'm a big believer in check it out anyways. Effort it, look at it, have someone look at it for you, put a couple hours into it, and tell you what it means, what it doesn't mean, where you could go with it. I have been telling clients, if you did buy business interruption, again, you had to have bought what's called BI coverage. If you have business interruption coverage, what does it hurt to have your broker put your insurance carrier on notice that you may have a business interruption claim? And that when this all settles down, you'll substantiate your claim. They'll send you a list of questions and documents they want, but at least you put your claim in, and they'll assign a claim number, and you can deal with it later, after you have the full impact, if we get to that point, that you can quantify it. So in any event, what we have here on page 12 is just some discussions about some of the impacts on employee benefits that you have to provide your employees in certain situations if it applies. I'm not an accountant. Every one of you probably have good CPAs. I recommend that if you haven't, I'm sure you have, your CPA is your partner in this process, both on extended tax returns, the Paycheck Protection Program documentation, what it covers, what it doesn't cover, how you can kind of navigate that. And I'm going to come back to that in a minute. Tax credits, all kinds of other opportunities to reduce your tax exposure. And of course, recoup some of the monies that you're advancing under these new programs. All of that, I think, is just generally put forth on page 12. Someone sent in a question, Maxine did. She wanted to know what are the conditions or legal parameters surrounding business loans and the fact that these businesses that borrow the money are crippled and need time to recover. Is the government putting anything in place to ease that pressure on businesses? Well, let me tell you, that's a question that is separate apart from the Paycheck Protection Program. That's different. It's before the coronavirus, you went out and borrowed some money for whatever reason. Times were good. You wanted to invest in equipment. And now your situation doesn't allow you to make those payments or make them timely. I know that certain states and certain types of lender actions have been stayed, like evictions, foreclosures, and things like that. In terms of business loans, I have not drilled down on that because I've not had anyone come to me and say that this money that I borrowed, I can't pay, and the banks are pressing me. I can tell you that my landlord, which is a big company, is looking for their rent every month, and if you hadn't paid it, I'm sure they're going to send you a letter. I know that a lot of folks who had business loans are foreclosing their business loans because they're afraid if they don't get in line first, there may not be anything there to get back, whether it's security in a piece of equipment or personal guarantee. So as of right now, I am not aware of any specific federal or state program that, as it relates to commercial debt, not personal debt, is stopping the lenders from coming after you and perfecting their claim. Now, the truth of the matter is that judges might be very sympathetic to the borrower and say, hey, look, these folks need to get back on their feet, cut them a break. During the 08-09 mortgage foreclosure crisis, all the judges in Florida were doing that. They were just refusing, not because it was consistent with the law or because they had legal authority to do it. They were just refusing to sign mortgage foreclosures. They just buried the files in their offices. They gave extensions. They deferred. That will probably happen a lot, and you're going to have workout opportunities. My son-in-law works for a large company that is constantly talking to its customers about, delaying and deferring debt obligations. They own a lot of buildings around the country, but so I think you have to have that discussion early and often with your lender. But do I know of a legal authority that says they're stopped in their tracks? No, I don't. Have I drilled down on it? No, I haven't, but I would have heard of it. On the personal side, I've heard of a bunch of stuff. So again, I think it's a case by case. Look at your loan documents, that sort of thing. That's something that is very specific to factually to you all. In any event, I'm going to keep moving. All right, so the next slide, which is 13, just talks about this new federal act or amended federal act and some human resources issues. These are basically employee issues. You just got to collect the information. Again, your CPA will be involved in this. I threw this in so that you would know that to the extent that you're encountering folks who are taking time off, either to care for a sick person, or they may be sick, or something that is either virus related or family leave, the Family Leave Medical Act or something like that, there may be some benefits, either the ability to get tax credits, the ability to defer and or recoup some of the money from your payroll taxes that you submit. You need to look at that very carefully. Again, CPAs are in the best position to give that advice. I want to roll because, I want to leave some time for some questions here. We're coming up on the hour mark of this. I'm going to page 14. I have spent a lot of time on the Paycheck Protection Program, which is part of the CARES Act. And then there are these other parts. So let's just kind of go through them on the left here. We got direct payments to taxpayers. So checks were mailed out to some taxpayers based on their prior tax returns. I know of some family members of mine who are working remotely who got a small check from the IRS. I know family members who didn't get anything for one reason or another. But so there were direct payments to to taxpayers and others in the approximate range of about $300 billion. And there was financial assistance for companies in need. I'm not really sure what that is exactly. It appears to be the aviation industry, the airline businesses, as you can see from the little graph there. Obviously, we've set aside money for hospitals and healthcare. You're going to see a lot of that money being utilized in the future, not only to pay for all the overtime at the hospitals, but to pay for new equipment that they bought, supplies they had to buy, and some other, ramping up efforts. Unemployment benefits, as you can see on the right side of the graph, funded $260 billion for that. The unemployment benefits are and again, I haven't gone through it personally, but I know folks that have had to, resort to that, and that's out there, and we talk about that a little bit, and that's on the internet. The second one down on the right side with the little shopping cart next to it, that is the Paycheck Protection Program, the $380 billion, which was increased by the third, federal government relief program, was increased by a couple $100 billion, I think, and that's and for those of you who have managed to navigate that program, what I call the PPP program, and get your money, congratulations. For those who navigated it and were frustrated as all get out, but then switched banks and got funded, congratulations. For those of you who are still getting, are not getting any relief, but are still seeking that money, I can tell you that the smaller banks are the best source of the funds. They're still sitting on a bunch of money. The big banks, I'm not gonna disparage them, but my experience was not a good one, and a lot of my large clients, it was not a good experience with the big banks. But in any event, and then the tax incentives are there. So that's the CARES Act, and we've kind of given you a run through of that on page 14. Some of these reforms may have a follow-along impact on the cost of construction projects. Obviously, added safety cost is going to increase the cost of construction. Whether you recoup it in the job you're on or future jobs, you'll have to negotiate that. It just depends how restrictive those requirements are or how financially expensive they are. And you can see the rest of the program there. I want to come and talk a little bit more about the Paycheck Protection Program because we get a lot of questions on that. And again, that's page 15 of the presentation. So what was the program? It was pretty simple. I mean, I've read the federal stuff. I've read the materials that came out. I quickly scanned it, and as it got, revised. And I want to tell you, as of last night, the Small Business Administration is promulgating new rules for that program to allow more opportunities to access the remaining funds, but also allow more flexibility in what items will lead to the forgiveness of the loan. So let's back up. The PPP loan is, you had to apply for it, you had to have the backup, there was a formula, it was fairly straightforward. If you had the backup, you put it in, they give you an SBA number if you're lucky, they fund you, but just before they fund you, they make you sign a loan document, a promissory note, and some other resolutions. Pretty straightforward, pretty simple, and the promissory note says in the first 6 months, no interest. After that, it's a very, very small interest for the next period of time. But what most people who wanted to go into the program wanted to happen is to take advantage of the forgiveness feature. And to get it forgiven, you had to comply with a number of things. So let me just go through the program real quick, the parameters, and I'll get to the issues. 10 million was your max request. We all know the stories of companies that got it and shouldn't have. The maturity schedule was 2 years. The interest rate was 1%. The deferral was 6 months to a year. The borrower's requirements was a good faith certificate that you needed the money, verification of a single force for assistance, which is going to be something very important, and no collaterals or personal guarantees were required in the loan documents. All of that was consistent with my experience. And I think they're going to water down the good faith certificates and the suggestion that you had no other source. They're not going to require you to have gone into your personal pocket or borrowed from other family members or that sort of thing. They're not going to create hurdles. The IRS, the Treasury Department, the SBA have said the following: if you took down anywhere close to $2 million or more than $2 million out of the program, you're going to get audited. Absolutely, that's going to happen. If you took down the average of the requests right up until the second level of funding was approximately somewhere between 150 to 180, and that's a moving number. The averages go up and down, but it was somewhere just between 100 and 200,000. Those folks are not likely to be audited by the government. However, the lender is going to want to see documents that you used the money, or that you maintained your payroll, that you had employee expenses, that you had the rent, you paid the rent, and some other utilities and some other small allowances. They're going to want to see that. And if you can show that you did that, or that you brought employees back, or you made payments to the health insurance and all that, you're going to have your loans forgiven. So that's the CARES Act in a nutshell. Most of the folks sitting here today have made it, who have gone into that program, have made it through to funding today. Now, there's a whole bunch of who may not have been funded or still aggravated and frustrated, and I've given you my advice on about the smaller banks, but those who have been funded, you're now in that part of the program where you have to comply with the program. You have to keep your payroll. You have to return your payroll for 8 weeks to that furloughing status quo, if you will, et cetera, et cetera. You just can't take the money, close your business, and run away. That's going to be a problem. Somebody's going to owe it back. In any event, moving on to the next slide, because the key to these webinars is to keep moving and to try to give you my perspective of what this all means. So this is a slide, many of these things we found on the internet. We're not taking original authorship for any artwork. That doesn't mean you can sue me, but this is pretty generic and typical. So we're talking about PPE. That's another phrase that is taking on heightened interest in our industry. For the bigger construction companies, for the bigger subcontractors, for the bigger projects, safety programs, safety meetings weekly, if not daily, safety officers, pretty much standard, okay? The bigger the project, the more complex the project, the more of that you saw. Now there's a whole new level of safety and health considerations coming into play that are layering on to the prior standard operating procedures, and it's the PPE. So what do we have now that we didn't have before? Well, the face mask. Okay, so what do you see? I go out on the streets every day. I see 30 different types of face masks. I see some stuff that's like out of a Halloween party. I see these big artifices that cover most of the face. It's like a Darth Vader mask. Then I see the more traditional, face masks, the less expensive, cheap ones, the tie-on, the reusable, disposable. Somewhere along the way, they're going to start requiring certain types in construction projects. Right now, they are probably requiring certain types. We've all heard about N95, KV95, I think, and some others. So you have to find out exactly which ones are required. I'm seeing those everywhere now, and I think those will continue on construction sites, especially since it's really hard to engage in social distancing on a construction site. I don't know how you do that. I mean, I can see it happening, but you have crews who work together to hang steel, hang drywall, hang metal framing, paint. So I don't know how you efficiently do your work and still stay 6 feet away. So that's why face masks and gloves are going to be an absolute requirement for those folks. And most construction sites, everyone wears gloves, but you see the superintendents walking around without them. You're going to see more gloves all the time, different kinds depending on what kind of work you're doing. But name it. So face masks, regular monitoring, safety guidelines are being followed. I am hearing at the cutting edge of this, saw an article the other day about temperature monitoring, testing on project sites, the big GCs, I'm talking about the national footprint guys and gals, they are going to have new equipment, new monitoring equipment. They're going to do their level best to create a program that heightens safety, because again, we don't have a vaccine. Until we have a vaccine for this virus, we're going to be in a new reality. Like I said in my 3Fs, that's the forever. So even if we get past this one, there'll be a worry about the next one. So a lot of what we're now learning to do, at least in the PPE business, is going to stay with us for a very, very long time until we get new technologies that can take the place of face masks or medical vaccines, et cetera, et cetera. So anyways, social distancing when possible. Again, that's a difficult situation in construction projects. I think you're going to see, best practices, literature to the employees about how to avoid physical contact, how to maintain personal hygiene. And I talked about Dr. Fauci, one of the other F's. Wash your hands. There are going to be washing stations with special liquids, better liquids than you get, at your office buildings or your convenience stores or wherever you're walking through. So there's going to be a lot more of that. There's going to be heightened training on all of these activities. I've talked about that. There are companies right now that are starting to offer as either an additional service or a new service, disinfecting and cleaning construction sites daily. Beginning of the day, end of the day, probably the end of the day more likely, but doing it in a way that's never been done before. Prior to this virus, your typical cleaning operation on a project was a temporary labor service company being hired by someone to come in and pick up garbage, cups, food articles, some debris created by the project and dumping it, or the subcontractors doing it who created it. And some jobs were better than others. This is a whole new world when it comes to cleaning projects. I heard the other day that New York, not too far back in the past, finally figured out that they had to start cleaning the New York subway system every night. Imagine how many cars, how many people, and how they were doing that every night. That's not just taking a rag and wiping handrails. I mean, if they're doing it right, it was almost a bath, an interior bath of sprays and solutions. So I don't know how they're doing it, but they're doing it, allegedly. So in any event, that's going to be, on projects, you're going to see a lot of that in the common areas in the projects, common areas being the staircases that lead to the various floors being worked on, railings, 8 places where people eat, the entry and exit points, and other areas. And of course, record keeping is going to go through the roof. What did you do? When did you do it? And how did you do it? That's going to be part of our industry go forward. and proper record keeping is going to be important. Are there going to be lawsuits coming out of this down the road? As these requirements get etched in stone for particular states, counties, cities, and projects, and then you don't follow them, and someone has an event, you might get sued. Now, how do you prove that something you did or did not do right is what caused this person to get it? I don't know. That to me is, that's a whole other world of litigation and expert testimony. But if you have an outbreak on a project, someone brought it to the project, and the question is, how did they get to the project, and how did no one know about it or stop it? So I'm just outlining the possibilities. The answers are yet to be determined. Those are the issues that we wanted to bring to your attention. All of this is evolving. As one government program comes to an end, another one may take its place or supplement it. Employer issues are just starting to manifest themselves. Unfortunately, people use these kind of events to file frivolous litigation. There's plenty of meritorious litigation, but frivolous litigation will be heightened in some way, shape, or form. You're going to have employer issues, safety issues, financial issues, contract issues. And that's why the one thing I urge folks, after all these years of practicing, it's not about me trying to find work for my group. It's making sure that when I do these speeches, I say, find yourself someone that you trust to give you good advice, whether it's a CPA, a construction lawyer, or some other professional, and try to, as we all want to prosper and be successful, that's about having best practices. So everything that I've tried to share with you is just some superficial information so that you have some knowledge that you can pivot off and stand on to reach the next level of knowledge that you might need for a particular transaction. If anyone here has any questions, I'm going to try and answer them as we go through here online or via text. If anyone has something they want to talk to me about, please feel free to call me or text me or email me. I'm in my office a lot. This is a quick aside. Almost all court actions have ground to a standstill. We have some hearings by phone. We do some depositions by phone, mediations. But by and large, the legal business the litigation side has ground to what I would call a slow crawl, and is just starting to plan for coming out of our own sort of lockdown. So there you are. Thank you on behalf of the Blue Book. Thank you, Lenny Serbini, Dina Sordo, for your support. I hope you were all able to hear and took something away that was useful. Thank you very much.
You're welcome, Oscar. Thank you so much. I really appreciate it. Great information. If you need anything, obviously, get a hold of Oscar. Great person, great attorney. If you have any questions for me, please reach out to me. Everyone have a fantastic day. I truly appreciate you guys coming and spending some time with us and learning some information that you didn't know. We're okay?
We're super duper. Have a good day and stay safe out there.
Thanks, guys. I appreciate it. Have a great day.
Thank you.